Are you or a loved one disabled? Do you feel alone, lost, and confused as to how to win your Social Security case? If you're watching this video, it's probably because you have so many questions and you're desperately looking for the answers. Hi, my name is Avi Libovic, and I'm the owner at Benefits for All and the lead attorney at Avi Libovic and Associates. Over the course of my 20-year career, I've overseen the processing and screening of over 500,000 disability cases, working with the largest hospitals, neighborhood clinics, primary care physicians, and even individuals who had no access to care at all. My strategies for how to win the case have made me one of the top experts in Social Security law in the entire nation. My life and my career were going great. And then one day it all came crashing down. It started first with some abdominal pains. And before I knew it, I'd been admitted to the hospital several times and I required multiple surgeries. I found myself unable to work and disabled and in desperate need of my own benefits. I understand exactly how you feel. I was in your shoes. And I'm going to take you through the process and help you and give you everything that I know so that you can win your case. I'm recovered and I'm back at work. And I have a newfound passion for helping disabled people because I myself have been there too. Call our office today for a free screening and to see how we can help you with your Social Security case. At the same time, enjoy these videos and webinars that we've prepared to help you understand how to win your Social Security case. Hi everyone, this is Avi Libovic and you're watching another amazing webinar brought to you by Benefits for All, where we teach you how to win your Social Security case without having to pay the cost of an expensive attorney. I'm standing here in beautiful New Mexico. Unbelievable, right? There's so much history over here. It's such a beautiful state. I can't get enough of it, right? Whether you're looking at some of the historical communities and you're looking at some of the historical landmarks that really have defined, New Mexico, right? Some of the towns and that relate back to the cowboys and relate back to the journeys that the cowboys would take along the Rio Grande, as they're going back and forth from Texas to California and the California Gold Rush, people traveling back and forth. It's just so much history here. It's amazing. You got to come check it out. Not just the history, also the beautiful mountains and the rocks and the formations and just the natural wonders that are here. The people who live in New Mexico, you have a beautiful state. If you've never been here, you should come and check it out. Today's topic on the webinars is exhibit files. Exhibit files? Okay, so I have some of my notes on my phone. I hope you don't mind. It makes it a little bit easier for me to stay focused as opposed to holding some papers that are distracting over here. So what does it mean, exhibit files? Okay, let's break it down from the beginning. You've applied and you submitted your application to the district office. Unfortunately, you did not win. You went ahead within 60 days and you submitted what? A request for reconsideration, again at the district office. And we know from those of you who've watched the webinars that the initial application is a little easier to win, right? Whereas the request for reconsideration is very difficult to win. Usually in most states, only about 12% of the people are winning. The rest of them are getting denied. Most of the cases are going to end up at hearing. Now the hearing is, by the time you get to the hearing, the process in some states, just from the request for hearing, could be more than 400 days. So if you go ahead and you take the 6 to 9 months for the application, and then you go ahead and beyond that 6 to 9 months, you take another 6 months or so, 6 to 9 months, depending on how quickly you provide the information or how quickly the district office can work on processing your case. The request for reconsideration gets denied, and then you request a hearing before a administrative law judge, right? And we said in some states it could be over 365 days until you get your hearing. So you're talking about 2.5 years from when you first started everything until now. Finally, I get my day in court. So let's talk about that. Before you go to court, you're going to get something called an exhibit file. Now, in some cases, you're going to be able to download it from the internet, right? You'll have a log on and you'll be able to get it as a log on. In other cases, they may mail it to you on CDs, depending on the state that you're in. Some ODARs are still mailing it. Some ODARs are not mailing it, right? ODAR, again, is the Office of Disability Adjudication Review. That's the name of the office where the judges are going to hear your case. Or if they don't mail the CD and you can't download it, you can certainly go to the ODAR office a couple weeks before the hearing and you can request the CD again and they'll give you the exhibit file. Now, what does it mean, exhibit file? Well, just think about all the movies that you watched, right? Whenever someone makes the opening statement or the closing statement, they say, and I submit to you exhibit A, and I submit to you exhibit B, and I submit to you exhibit C, and they point to different things, right? Pictures or movies or big boards with things, right? The movies, right? Exhibits. The same with your case. Think of how much you've submitted to Social Security, how much documentation. It's unbelievable. Everything that you've submitted is what? Is an exhibit. Everything. From the first form to the last form, from the first medication to the last medication, from the first medical record to the last medical record, from the first doctor letter to the last doctor letter, from the first, even things having to do non-medical, dates, proof of date of birth, proof of citizenship, income, resources, bank statements, right? Title or deeds, title either for a car or for a property or deeds for a property. Everything is an exhibit. So before the hearing, you as the claimant are entitled to the exhibit file. The exhibit file is everything that the judge, the administrative law judge, the ALJ, is going to look at in order to make a decision on your case. Everything. So the first thing is you want to get your hands on it, and then you want to open it up. Again, if you need help opening it up, that's probably beyond the scope of this. When I mean opening it up, meaning you're going to have to look at it on a computer. So if you don't have a computer, go to a public library, and I'm sure that the librarian will show you how to use it. In many of the ODARs, they actually have 2 computers there that are free and available for you to use in preparation for your hearing. Just schedule some time to go down there and say, listen, I want to look at it, and they can help you open it up. All right, but once you open it up, you need to understand how it's structured so that you can go ahead and understand it all. Now, when you open it up, you're going to see within the exhibit file everything again that you submitted and everything that they have about you, everything. Even if you have an old application and an old hearing, right, with the judge, an old application that resulted in a hearing that got denied will also be in that exhibit file. But generally, you're going to go ahead and you're going to find that within the exhibit file, right, you're going to have a section A, you're going to have a section B, you're going to have a section C, a section D, a section E, and a section F, right? A, B, C, D, E, and F. So let's talk about these. We'll go through them quickly, and then maybe we'll make some separate webinars individually on each of the sections, but let's just try to talk about them. Section A. What is Section A? Section A is any type of document, right, that has to deal with a payment document or a decision. What does that mean? So it says it can include either the SSA Form 831. The SSA 831 form is the disability determination and transmittal. That will basically mean some of the decisions that were made earlier on in the case. They're written in a certain format on a paper and they're forwarded over to the judge and the ODAR so you can see it. It'll be the SSA 831 in Section A. Or it could be a disability determination explanation. Remember we discussed on a webinar that when you submit your application to the district office looks at the income and the resources and the citizenships and the residency, but then they send your medical files to a disability determination services, the DDS, to make a decision. So Section A will have the decision by DDS. And you're going to want to know that because you want to understand why you were denied. You remember, you're prepping for your own hearing and you're going to represent yourself, and I'm going to show you how to do it. In addition to the SSA 831, which is the transmittal sheet, in addition to the disability determination explanation, you may have an 832 and you may have an 833. That's an SSA 832 and an SSA 833, which are, it's not in every case, a Title II or a Title 16. It's called a ceased disability or a continued disability, which basically means that something happened where they stopped your disability or the payments. You may have gone to jail, you may have left the country, something would have happened, or they're starting it up again and there's some information regarding that. There also would be previous decisions, whether it was dismissed, whether it was won, or any type of revised decisions that may have been done. And, finally you're going to have in Section A, the ALJ or a senior attorney in the ODAR office, you're going to have their decision in a pending case, right? And then you're going to have, if
if you hire a representative, you're going to have the representative fee. So that's in section 1. What does it mean, the representative fee? Well, you sign a paper. It's like a contract, basically saying, I hire my attorney and I'm going to pay him this much. And the court needs to know who you hired, how to contact them, what the agreement is, when you signed it, and how to make the payments to what address. So that paper that you signed, the fee agreement, is also in section A. Let's talk about section B. Section B of the exhibit file, right? Remember, there's A, B, C, D, E, and F. We're on B. Is what they call jurisdictional documents and notices. Jurisdictional documents and notices. What does that mean? So the ODAR office will, as they prepare it, they're going to put the following type of documents in section B. And it's very neatly under B. You just click the tab and then B will open up and then you can click, whichever one you want. They'll all be labeled. It'll be very easy to see what it is. You don't have to be scared. It can, number 1, it will have the initial determination, the form and the notice, right? Remember, you submitted an application and got denied, so it's going to have like the denial letter, so to speak. You're going to have in there the request for the reconsideration and the notice, right? If your initial application got denied, you submitted a request for reconsideration, so they're going to have that in there. And the notice that was denied. You're going to have the request for hearing, right? Your actual form that you filled out. We have a webinar on which forms to fill out. The request for hearing. If there was a cessation notice of planned action, meaning sometimes some of you were on benefits already and you got a letter from Social Security saying we're stopping your benefits on so-and-so day, either because of an overpayment or because of something else that happened. If you're fall in that category, you'll have a cessation letter in section B. If you had an overpayment, you'll have a notice of the overpayment. Again, whereas in section 1 you had a representative fee authorization, they're going to have that again, but this time they're going to have it together with the SSA 1696. The 1696 is the appointment of authorized representative. That's if you have an attorney and you sign the forms. That form saying who you signed will be there again in section B. If you had another attorney and that attorney withdrew prior to the hearing or somewhere along the line, it's not uncommon sometimes to have 2 attorneys or 3 attorneys helping you through the process. So if you have an attorney withdrawal letter, right? Someone started and then either you fired them or they said, I don't want this. You're gonna have the attorney withdrawal letter. You're gonna have also perhaps a waiver of a right to appear. Some cases, not every case, you may not want to show up to the hearing. So your representative shows up. In that case, you may waive your right to appear and that letter would be there. You may have a substitute party form. A substitute party form, we have a webinar on substitution of parties. It really only happens in 2 different cases, 2 different scenarios. The easiest scenario is Title 2, right, SSDI. If you're entitled and you have the right number of benefits and you applied for Title 2 benefits, Social Security Disability Insurance, and then, God forbid, you pass, your next of kin can substitute in for your benefits. Why? Because that's like money that you put in a bank account to wait for you when you got, disabled. Now, you haven't been given the money yet, but you have a claim for the money, right? So your family member, your next of kin, can substitute in for you. The other example on a Title 16 is usually if you're receiving general relief. Sometimes the county, right, from the general relief or the general assistance in your state will substitute in as a party to try to collect what they call interim assistance reimbursement, IAR. Basically meaning that, I don't know if you remember when you agreed to take your welfare benefits or you agreed to take your general relief or general assistance, GA, you signed a letter saying if I win a lawsuit, if I win $1 million, if my Uncle Harry or Aunt Sally leaves me a huge loan, that you're agreeing to pay back the county all the money that you borrowed, right, for your GR checks, right? In some states, in California, I think it's $221 a month. So if you're on it for 10 months, right, they would take $221 times 10, and before you get your money, if you get a proof of disability, you have to pay back the county the $221 times 10. Fine. I don't want to confuse anyone, but that's a substitution of party for SSI with a county, and it's called, they're requesting back their interim assistance reimbursement. That's in section B. And then you may have also a withdrawal of a request for hearing. You may not go to hearing, you may withdraw, but you'll still have an exhibit file, and if you withdrew, in order to keep all the documents together and in a safe place for review later on in time, or for an appeal if you need it, your withdrawal of the request for hearing will also be in section B. Not in every case, but if there's a situation where 2 attorneys are in the case and both attorneys, after you get approved, have to go ahead and they have to list out their fees and their hours. It's called a fee petition. The fee petition will be in section B also. There'll be some acknowledgments possibly some forms again from the ODARs regarding the request for hearing and any attachments that are part of it. You'll have the notice of hearing, which says, it says your name, and it says you requested a hearing on this date, and it says your hearing has been granted, and it will tell you where to show up, at which office, at what time, and who's the judge, the notice of hearing. Section B, if there's a continuance, meaning you had a hearing and you showed up and it got continued, right? Or if something happened and you needed to postpone it, either the postponement or the continuance letter will show up in Section B. And then even if you have a situation where it's complicated, I don't want to get into it now, but you have an appeal to appeals council or district court, maybe gets remanded back for another hearing. If that's a scenario and you're now back for your second hearing, you'll also have what they call the request for the appeals council review, and possibly even the appeals council review or the federal court decision remanding it back down. That will all be in Section B. Why? Because Section B deals with jurisdictional documents and notices, and everything that I just listed dealt with that. So number one, Section A is payment documents, right, and decisions. Section B is jurisdictional documents and decisions and notices, right? What about Section C, right? What's going on in Section C over there? In Section C, sorry, I'm pouring my foam over here. Section C, my apologies. You know, the problem with some of these devices that when you need them right away and you're standing in an area without, what's it called, without data, it doesn't come down so quickly. We're going to go ahead and we're going to take for a second, we're going to skip Section B, Part C of the exhibit file. We're going to come back to it, right? We're going to go now to Part D. Why C? We're skipping in a minute, I'll let you know, but let's just skip C for, we're going to go to D. D has all the non-disability development, the non-disability development. What would that include? It would include the application. It would include a written statement or record of an oral inquiry indicating an intention, an intent to go ahead and, you know, commence with your application. It may have a birth certificate and proof of age, as we said. It might have your earning record. If you're applying for, if you've worked at all, whether it's SSI or SSDI, it'll have your earning record and how much money you had. If there's any workers' comp or VA decisions or any other type of notices from other agencies, that will be in that Section D. Section D will also include evidence of death, in case we spoke about before, if there's a substitution party, right? They can either show a death certificate, right, and the substitution party, so that would be in there. Or a survivor case, you know, if it's a surviving spouse and they're eligible, that will be there. It will show also verification of work activity that was engaged in by the claimant after you submitted your application. Remember, you can't work and earn more than SGA, but you can work and earn under SGA. So if you earn some money during that time period from when you filed your application until now, that earning record, right, that earning record and that information, the verification of any work activity after the application will also be in that Section D. There'll be some information possibly about contact attempts or successful contact that was made by the district office or by the ODAR to you. They basically write in a computer, I called the claimant on this day, I mailed them on that day, we spoke. It just talks about the contacts, so the judge knows how much involvement there was and whether they were in communication with you. And then in the event that you somehow call your congressman or senator or whatever it is, there'll also be any congressional inquiries or letters. That will also be in Section D. Let's go to Section E. Disability-related development and documents, right? In there, we're going to have all of the different forms that we talked about in all the different webinars. If you remember, and if you don't remember, you need to watch those webinars again and be familiar with it, or you can open up your exhibit file while you're listening to this tape. In Section E of the exhibit file, you're going to have the SSA 3368, which is the disability report for adults. If, on the other hand, the claimant is a child, you're going to have the SSA 3820, which is the disability report for a child. You're going to have a 3369, which is the work history report, right? And even though you have an SSA 3368, which is the disability report for the application, or you're going to have a separate one, the SSA 3441, which is the disability report for appeals, for reconsideration and appeals, okay? So let's keep that straight. You're always going to submit a disability report. The difference is an application. If it is, you're submitting the 3368, and if it's on appeal, you're submitting what? The 3441. You're going to have the SSA 454 if it's necessary, which is the report of a continuing disability. In Section E, you're also going to have the SSA 455, which is any disability update report. the SSA 821, which is a work activity report as an employee, or the 820, which is the work activity report if you're self-employed. School records, if you have any school records, again, if you're dealing with a minor. Sometimes many of the children who are applying who have attention deficit disorder or hyperactive disorder, they may have an IEP, which is an individualized education plan, which is set up for the child, right? You need to have that in there, and hopefully you've submitted it to them and they've included it in this section, so that's there for you to review. If there's any teacher evaluations, they may have also submitted that as report cards. You may have supplemental requests for more information, or remember, if you submitted something and the district office or even the ODAR wanted more of it, they may send you some letter saying we want more, or it's not complete, send it to us. That would be in this section E. Any letters that you've received from employers or family members or friends or people who are familiar with your situation, right? Letters on your behalf, that would be in the section E. In the hearing, you'll notice that there is sometimes an ME, that's the medical expert, and there's sometimes a VE, that's the vocational expert. The medical expert is there to give testimony to the judge as a doctor. I'm the medical expert, I've reviewed the medical records, and this is what I think. The VE, the vocational expert, that's someone who specializes in jobs. They know all the jobs. They know every job on the planet. They know what skills you need, how much education you need, how many tasks need to be done in stuffing an envelope, or how many steps need to be done in, ringing someone up at a cashier. If you had sent some questions or interrogatories to a VE, or if it's a second hearing now, maybe it was continued, right? You had a second hearing now, and there were some interrogatories, or the judge left the record open until more information. Now you're coming back again. Those interrogatories, those questions and responses from the VE would also be in section E. And you may sometimes find also a written summary of the case or written statements about, you yourself, the claimant. Okay. You'll also find in section E, as we're coming to the end, a disability determination services worksheet. That's basically a worksheet that they fill out, which helps you clearly identify what they were looking at, which impairments, which listings they were looking at, and gives you a better understanding of the path that they took. And then finally, what they have here is an electronic disability collect system, or the EDCS, which is the routing form. You don't need to worry about that so much. It kind of just shows, how the case made it to where it's at. Okay, so we've handled A, B, D, and E. We've skipped C. Okay, I didn't forget. Section F. What is section F in the exhibit file? It's the medical records. This is the meat, right? The meat in the sandwich. The other stuff is important too. But if you have no medical records, and I've seen some exhibit files where section A, B, C, D, E is filled. When it came to F, there was nothing there. No treatment. So let me tell you something. If you have no treatment, what do you think is going to happen to you at the hearing? You lost. No judge, I don't care how much you say, ouch, ooh, ee, oh, my back is hurting, my legs are hurting, I can't breathe, shortness of breath. No judge is approving you unless you can show what? Objective medical evidence. Objective. Objective means it's not from your friend or a family member who's filling it out. It's from objective, from a third party, from a physician. Careful when I say physician. Some people submit chiropractor stuff. Some people submit acupuncture stuff, homeopathic, energy notes from some energy doctors. Those are fine. You can submit those, but they don't have as much weight as a physician. Sometimes some of the letters you get might be signed by a nurse practitioner. That's also okay, but you know what? A nurse practitioner is not the same as what? Is not the same as a doctor. A physician's assistant, a PA, which has become very popular now with some of the healthcare plans that we have, right? They're trying to cut costs. So instead of having the doctor see you, they have the physician's assistant see you, the PA. The PA sees you, checks you out, right? Does an examination on you, writes out what's needed, and then goes to the doctor. The doctor reviews the notes and just signs off on it. Okay, the PA is not the same as a doctor, so you need to get doctor stuff. So let's go through again, section F, your medical records. Treatment records, hospital records, laboratory records, imaging, x-rays, imaging, MRIs, imaging records, outpatient notes, right? Some people go to outpatient, even if it's an outpatient treatment facility for drug or alcohol, the outpatient notes should be in there. Consultative examinations, CE. Sometimes, if they feel that you don't have enough medical records, Social Security will schedule another doctor to look at you. That's a doctor who's paid by the Social Security Administration. It's called a consultative examination, a CE. You'll go to this address, you'll go to this location, the Social Security doctor will look at you 15 minutes, 20 minutes, a half an hour, depends the city. Some places it's an hour. It's rarely an hour, but they're going to look at you, and then they're going to write a decision. Now, the judges rely on those decisions, and part of what you're going to do at the hearing is you're going to need to possibly neutralize that CE statement, because after all, if someone only looked at you for 15 minutes and then they didn't pick up on everything and they wrote a very terrible, very harmful report about you saying, oh, you're fine, you're terrific, that's okay, that's not good. But if your treating physician, if the hospital, right, has records and laboratories and imaging that shows that there's a problem, so which is the judge going to give more weight to? Is the judge going to give weight to what? The CE exam that saw you for 15 minutes, that doctor, or to the hospital that you were checked into for 10 days? Obviously the medical records, but you need to look at that CE exam so you know how to discuss it and rebut it and neutralize it at your hearing. Okay, we're still in section F. If you have any medical opinions or any analysis or what they call a RFC, residual functional capacity questionnaire. There are these questionnaires that are either broken into something that has to do with your physical health, a questionnaire that has to do with your mental health, or then there's specialty questionnaires that has to do with a specific part of your body, your eyes, your muscles, your hearing, right? And those will be filled out by specialists. And those are, the RFCs are basically sets of questions that you send to the doctor. We will have them on the website so you can check them out and see what they are, that basically ask the doctor to respond back and give his opinion above and beyond the medical records, as to whether or not he or she thinks that you're disabled. Those RFCs are very, very important. I encourage you to download and watch the webinar on those. They're very, very important. And then, again, we talked about school records if you need them, as well as any letters of unsuccessful attempts to obtain medical evidence, okay? There's some times where you may have gone ahead, and I've seen this happen several times before, where you go ahead and you request letters from a jail or from a clinic, and those letters are very, very important for you. You find that they're essential to your case, and then you request them, and what happens? They say, oh, we don't keep anything more than 5 years. It goes into archives, or it gets scanned and stored. And then you say, okay, no problem. Go ahead and give me the scans, give me the archives. Ooh, we don't really know. You know what I'm saying? We don't really know where those went. What do you mean you don't know where those went? Those are my medical records. I need those medical records. If I don't have those medical records, how am I going to go ahead and how am I going to win my case? And the answer is, sometimes you're not going to be able to get them. So the best you can do is, instead of saying I have nothing, right? You're going to go ahead and you're going to want to go and get a letter from the. You're going to want to get a letter from the office that you requested everything from, the medical office, and you're going to want to go ahead and you're going to want to ask them. You're going to want to ask them, right? What are you going to want to ask them? You're going to want to ask them to please write a letter to the Social Security judge saying that so-and-so has requested this letter or this medical records on this day, but we don't have them anymore. That way the judge at least knows that you tried to get the medical records even though you couldn't get them. I remember a situation where it was a county hospital in Los Angeles. I'm not going to name which county hospital it was, and I'm looking to download one more thing over here. And what happened in that county hospital? There was a huge flood. What does that mean, a huge flood? A huge flood. There was a drip. Right? You have floods in your basement, you have floods in your house from the rain. That's what happened here. And you know what happened? All these medical records were just destroyed. Just destroyed. It was terrible. It was a disaster. What are we going to do? We need those medical records. Well, we couldn't get them. There's nothing we can do about it anymore. So because they couldn't get them anymore, instead of giving the judge nothing, you might as well go ahead and ask for a letter from the hospital asking for what? Excuse me. Asking to say that the case files are no longer available, the medical records are no longer available, they're destroyed or they're lost, whatever it is, and at least that way the judge will go ahead and he or she will understand and they will not hold that against you. Okay, so we've covered A, B, D, E, and F. Why did I leave out section C? The reason I left out section C is because often section C in the exhibit file, there isn't much there. The documents in section C are usually just what they call working documents. Excuse me, those are papers that the judge may need to look at, or that the ODR may need to look at, or The judge may look at even regarding the district office to see what efforts they made. If they requested medical records, if they tried to make a call, if they tried to do anything. They're called like working documents. It's a printout of a print screen or something that they may have used to gather some information. But once they get the information, they don't look at the print screen anymore. Once they receive the medical records, they don't care about the letter that says, can you please send the medical records, right? So Section C is not something that you need to be worried about right now. There very often will be very little in there. You need to focus more on A, B, D, E, and especially F. So there you have it, folks. You have the exhibit file, which is the meat of the sandwich, right? The meat of the sandwich for your hearing. Everything that is going to be used, not against you, but everything that's going to be presented in your hearing before the judge, right, at the ODAR office, is going to be in the exhibit file. If it's not in the exhibit file, you must add it to the exhibit file. Meaning, let's say before the hearing, you submitted whatever medical records you have, fine. And then 2 days before the hearing, boom, you had to go to the emergency room. Boom, you had to go to the doctor here. Boom, you need to get some new medication. And you know what, you haven't had a chance to give those new records to Social Security yet. So you bring those papers with you to the hearing and you say, Your Honor, as we're starting, I need to add something to the exhibit file. So if you're going back to Section F, which is the medical records, let's say if you had 5 hospitals and 3 doctors, so you have 8 things, right? 8 things, exhibit 1, 2, 3, 4 in Section F. Well, now, Your Honor, I need to add a 9th thing. And the judge, he or she will add that on right there. I think what you need to take away from this webinar is that preparing for a hearing is a serious thing, and there's going to be several webinars about this. Ideally, we'd like to have an opening statement. Some judges will allow it, some judges won't. But we're going to teach you how to prepare one and how to have it ready to go. Very short, very small, right? My name is Avi Leibovic. I'm so-and-so years old. I so-and-so have X amount of education, right? For the last 15 years, I've been working as this. On so-and-so date, my alleged onset date, I began feeling sick. I couldn't work anymore. I've been diagnosed with 1, 2, 3. I'm going to be making the argument that 1, 2, and 3 match up with either the listings, step 3, remember we had the 5-step sequential in some of the webinars that we did. We're going to list the impairment. And then you're going to say, and if it doesn't match up with the impairment in step 3, we're going to list the grid rule, right? Another webinar, download it. And we're going to give the grid code number to say, and if I don't win at step 3, I'm making the argument step 4 and 5 that I meet the grids, right? I grid out. Once you have that down, and once you can understand the exhibit file, and you know how to get it, and you know how to open it, and you know how to read it, it's not so hard. It's not so hard. You don't have to be scared. I'm going to show you everything that I know. Everything that I have here, I'm just giving it to you. I'm giving it with love, and I know that you can do it, okay? Until we meet again, right? My name is Avi Leibovic. If you need help, www and benefits for all. And A-N-D, benefits, B-E-N-E-F-I-T-S, for F-O-R, all, A-L-L.com, and benefits for all. We took it, as we said many times, because with liberty and justice for all, right? At the end of the Pledge of Allegiance. Justice for all, due process, my day in court, my day in court to make sure that my benefits are not taken from me without a fair hearing and due process. Just like you're entitled to the fair hearing, right? Justice for all, due process, you're also entitled to your benefits, benefits for all. We're going to help you get your benefits. We're going to make sure the process is fair. We're going to make sure that your rights are protected, and we're going to make sure you win your case so you don't have to pay the expensive attorney fees that are ordinarily charged on a case like yours. I look forward to discussing anything that you want with disability, right, in one of the upcoming webinars. If you have a topic that you'd like me to discuss, write in, email it in, we'll get the webinar created. We'll put it up on the website. You'll be able to download it and get your answer, maybe even the same day, right? Maybe even the same day, in a fresh new webinar. And you can feel good to say, hey, I had a good question. Now, you know, they made a webinar about it. And all these people, thousands of people, can benefit because of the question that you sent in. If you have something that needs to be answered that's more specific, call the office, www and benefits for all. The phone number is on the computer screen. Click on the webinars, learn the webinars. And I look forward to learning with you again. All the best, feel good, and benefits for all, Avi Leibovic. Thank you very much.